Brazil's LGPD and China's PIPL, Brazil's General Data Protection Law, and China's Personal Information Protection Law represent landmark privacy legislation in their respective regions, setting new standards for data protection and privacy rights. These laws not only reflect global trends towards enhanced personal data protection, but also come with unique characteristics shaped by their socio-economic contexts. Understanding these regulations is crucial for privacy managers as they delineate the framework within which organizations must operate to protect personal information effectively. The LGPD, enacted in 2018 and effective from 2020, aligns closely with the European Union's General Data Protection Regulation, emphasizing the importance of transparency, consent, and data subject rights. It applies to any organization processing personal data in Brazil, regardless of where the organization is located, thereby extending its reach beyond national borders. The law mandates that organizations obtain explicit consent from individuals before processing their personal data, except in specific circumstances, like legal obligations, or when processing is necessary for the execution of a contract. A practical tool for ensuring compliance with the LGPD is the implementation of a robust data mapping process. This process involves identifying all data flows within the organization, categorizing data based on sensitivity, and assessing the purpose of data processing activities. By conducting data mapping, organizations can establish a comprehensive inventory of personal data, thereby facilitating effective compliance with the LGPD's requirements. In parallel, PIPL, which came into effect in November 2021, is China's first comprehensive data protection law. It shares similarities with the GDPR and LGPD, but also introduces distinct features tailored to China's legal and cultural landscape. PIPL emphasizes the protection of personal information rights and interests, outlining principles such as legality, legitimacy, necessity, and good faith in data processing. It requires organizations to obtain explicit consent from individuals for data processing, except in circumstances where consent is not required by law. One of the key actionable insights for managing PIPL compliance is implementing a data protection impact assessment framework. This framework assists organizations in identifying potential risks associated with personal data processing activities and evaluating the impact on individuals' privacy. By integrating DPIAs into their data governance processes, organizations can proactively address privacy risks and demonstrate accountability under PIPL. A comparative analysis of LGPD and PIPL reveals both shared principles and divergent approaches. Both laws underscore the necessity of obtaining data subjects' consent, but PIPL places a stronger emphasis on specific consent, requiring organizations to provide detailed information about processing activities. This necessitates the development of clear and comprehensive privacy notices and consent mechanisms. Organizations can benefit from leveraging privacy management software that facilitates the creation and management of consent records, ensuring that consent is obtained, documented, and easily retrievable. This software also aids in implementing consent withdrawal processes, allowing data subjects to exercise their rights efficiently. Data subject rights form another critical aspect of both LGPD and PIPL. Under LGPD, individuals have rights including access, correction, deletion, and data portability. Similarly, PIPL grants individuals rights such as access, correction, deletion, and the ability to object to data processing. To operationalize these rights, organizations should establish clear procedures for managing data subject requests. A practical framework involves setting up dedicated teams or points of contact for handling these requests, implementing a ticketing system to track requests, and ensuring timely responses in accordance with statutory timelines. By adopting this structured approach, organizations can enhance their responsiveness to data subject requests, thereby fostering trust and compliance. Cross-border data transfer regulations present another area of focus within both LGPD and PIPL. The LGPD imposes restrictions on international data transfers, requiring organizations to adopt specific safeguards such as standard contractual clauses or binding corporate rules. PIPL, on the other hand, places stringent conditions on cross-border data transfers, necessitating security assessments and requiring organizations to obtain specific authorization from relevant regulatory authorities. Addressing these requirements necessitates the development of a cross-border data transfer management framework. This framework involves assessing the legal basis for data transfers, implementing appropriate safeguards, and maintaining records of transfer activities. By adopting a systematic approach to cross-border data management, organizations can ensure compliance with the respective legal requirements and mitigate potential legal risks. One of the significant challenges posed by both LGPD and PIPL is the enforcement of compliance and the penalties for violations. Under LGPD, organizations can face fines of up to 2% of their revenue in Brazil, capped at 50 million Brazilian reais per violation. PIPL imposes even more severe penalties, with fines reaching up to 5% of an organization's annual revenue, or 50 million yuan. To navigate these challenges, organizations should invest in privacy compliance training and awareness programs for employees. These programs should emphasize the importance of data protection, outline the legal obligations under LGPD and PIPL, and provide practical guidance on implementing privacy controls. By fostering a culture of privacy within the organization, privacy managers can mitigate the risk of non-compliance and enhance overall data protection capabilities. Case studies further illustrate the practical application of LGPD and PIPL. For instance, a multinational technology company operating in Brazil leveraged a comprehensive data governance framework to achieve LGPD compliance. This framework encompassed data mapping, risk assessments, and the implementation of privacy-enhancing technologies. By adopting a proactive approach to data governance, the company not only ensured compliance with LGPD but also enhanced its reputation and trust among customers. Similarly, a Chinese e-commerce giant implemented a robust consent management system to address PIPL requirements. This system integrated seamlessly with the company's existing customer relationship management platform, enabling efficient consent collection, management, and withdrawal processes. As a result, the company achieved compliance with PIPL while simultaneously enhancing customer engagement and satisfaction. In conclusion, navigating the complexities of LGPD and PIPL requires a strategic approach that encompasses data mapping, DPIA frameworks, consent management, data subject rights management, cross-border data transfer frameworks, and privacy compliance training. By employing these practical tools and frameworks, organizations can address real-world challenges, mitigate legal risks, and enhance their proficiency in managing privacy compliance. As privacy legislation continues to evolve globally, privacy managers must remain vigilant and adaptable, continuously refining their strategies to align with emerging regulatory requirements. Through a commitment to proactive data governance and a culture of privacy, organizations can not only achieve compliance with LGPD and PIPL, but also build trust and resilience in an increasingly data-driven world.